meeting to order. Welcome to meeting number 66 of the House of Commons Standing Committee on Citizenship and Immigration. Bill S-245, an act to amend the Citizenship Act, today pursuant to the order of reference of Wednesday, November 16th, 2022. The committee will resume consideration of Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. We are continuing our clause-by-clause study of the bill. When we left, we were on Clause 1. Madame Lalonde had just moved Amendment 5, so the floor is open for the debate.
Madam Chair, Clark is doing really fabulous work. Even ordering the food is very healthy choices. So
good.
That's good.
That's good. So we are on G5. Mr. Kimmich.
Thank you, Madam Chair. If we could just get, because I'm looking at G5 right now, and it is one of the longer clauses, and I know we just started right at the back end to it. It's to fix the unintended consequences from the June 15th date, which I guess Government 4 amendment was going to solve. So I would just like to have an explanation of the interaction, like what exactly is it solving, just so we have it on the record.
Okay, so Ms. Girard, would you like to
Thank you, Madam Chair. So to pick up on the explanation that was given last time, this amendment is basically a transitional provision which is necessary for legislative consistency and to enable the department to operationalize the provisions of the bill as amended this far. And the amendment is doing a couple of things. So the first is that it's clarifying that those whose citizenship is being restored by the bill are being restored back to the date of their loss, and that those being restored where they have children, those children are subject to the first generation limit, and that if they've received a grant, they're now deemed to be citizens by operation of law. So that is the first point. The second point that's important to emphasize on what this transitional type provision is doing is that it's safeguarding against any unintended loss, in that the amendment is needed to ensure that anyone who's already a citizen when the bill comes into force, including the children of those whose status is restored under the bill, will remain Canadian citizens. And that was an important safeguard that was also in place or a feature of the previous legislative amendments of 2009 and 2015. And so in summary, these changes or this amendment is needed to enable the government's implementation of the bill as amended and to facilitate the department's issuance of proof of certificates of Canadian citizenship. Thank you.
Mr. Reddycop.
So just to make sure I understand this, the original S-245 as presented had just a few words, and these words here that take up more than a few words are to replace those words to make them do what the original intent was of the originator of this law. Is that a fair statement?
Ms. Girard?
Yes, they're transitional provisions that are required to enable the department to implement the bill and to guard against unintended consequences of the bill, such as, the bill, as we've discussed, is automatically conferring citizenship on some, and that can have an impact on the children of those people. And so one of the very important features of this particular amendment is to ensure that anyone who is a citizen on the day that the bill comes into force remains a citizen, even if their parent, for example, those Section 8 loss cases, are becoming automatic citizens back to the time of their loss, Thank you.
Okay, so I think I understand. So this, because that was one of the complaints that we heard during the testimony, was that potentially somebody who was a citizen could get messed up from these words. So that makes sense. Does this amendment relate to any of the previous amendments that we've made, or does it kind of stand on its own?
Ms. Girard?
Well, I would say that in general, this amendment is also relevant to those previous changes, in the sense that as an example, with the Section 8, the narrow cohort that the sponsor of the bill was looking to address through the bill as drafted, this committee has voted an amendment to extend that remedy to all of the Section 8s. And that will, by restoring the citizenship to those Section 8s, that may have an impact on the children of the Section 8s who have been born abroad. And so this transition provision will also benefit that larger cohort. To give a practical illustration. Thank you.
So I guess another way of asking the question is, if we had not passed the previous amendments, would this amendment still stand as it is?
Yes, I believe it would, in terms of the aspect of this transitional provision that speaks to clarifying that anyone who is a citizen on the day of the coming into force of the bill remains a citizen, as an example.
So I'm just going to go back to territory we've gone over before, because there was a previous version of this bill, S230. When did the department discover? You had talked about doing a legislative review, I think, last time, when S245 was coming through, and that's when the department identified that the original wording of S230, which, I mean, this is what we're have gotten rid of and now are amending in order to avoid unforeseen consequences that you just described. When did the department discover those?
Ms. Girard?
Madam Chair, I can't recall exactly when we began our deeper study of S245. I can't recall offhand, but it was some months ago in preparation for these hearings that study was undertaken. Thank you.
So did something change that the department discovered that there would be unintended consequences if the wording of S245, which was S230, was kept as is?
Madam Chair, nothing changed. It was just as a result of the regular unfolding of the legislative process. After the testimony of those previous colleagues at that earlier stage, as the bill moved forward in the legislative process and in preparation for these hearings that the department undertook, the deeper, more technical study and analysis of the bill with Department of Justice colleagues in order to be able to testify as to the issues with the drafting of the bill.
So I just wanted to know, is it IRCC or Justice Canada that identified the problems?
Initially, it was the IRCC experts, some of whom are here with us today. But that is a study that is done jointly because we look for things that the department can generally identify on its own. And then we look to colleagues at the Department of Justice for anything that we may have missed, and also to confirm our own analysis. Thank you.
So you mentioned that it was on in preparations for when the House of Commons would be considering it. The bill was passed in May of 2022 by the Senate, and so I guess the department waited until you saw whether the House of Commons would indeed take it to the committee level before considering it. are any of those reviews, like, would you be able to, like, provide them to the committee? It would just help going forward if we knew if I knew everything that you know in that review for the following amendments that are coming afterwards, the considerations that the department gave and kind of how you went about identifying potential unforeseen consequences and future potential lost Canadians that we've discussed before in prior meetings. Is that something that can be shared with this committee?
Madam Chair, the issues with the bill, such as they are ones that I already took care to outline in my first appearance before this committee in some detail. So I think I would consider that those issues, such as we were able to identify, are already on the record with this committee. Thank you.
So I'll take it to mean I can't have the expert analysis that was done by the department, just because that would help me understand the drafting differences between S230 and S245 and kind of the thought process for the amendments that are being proposed at this committee and future amendments that might be proposed on this bill. There's lots of different lost Canadians. This is a very complex piece of legislation. So I'm just curious why we can't have those documents.
I think Ms. Gerard mentioned that, like, when she came for the first time for the hearing, she outlined the details on that. So maybe you can have a look at the answer to. Okay. Yeah.
Those are statements based on like documentation that the department holds. So I'm wondering whether I can't have those documents that inspired or informed the speaking notes that were obviously used to prepare by the civil servants who are before the committee, because they obviously know more than I do. I would just like to have some of that information.
Thank you, Ms. Gerard.
Well, I believe that my remarks itemizing those issues were tabled with the committee in both official languages as is required. And Madam Chair, in terms of the technical drafting issues, the follow-up to those remarks are already reflected in the government amendments which have been shared with this committee. Thank you.
Okay, well, I'm hearing that no, I can't have those documents. So, but I have a problem because there's lots of questions we've asked in the last few weeks that this bill has been considered, and we haven't received responses yet. And just today, I saw that we received a response to my colleagues, Ms. Rempel-Gardner's questions about getting the original form, I believe, for Afghanistan, and that was sent over. And I got responses to questions I asked at this committee November of 2022 on 4 or 5 different issues, and I've gone through them now. But since that time, I had to file OPQs and access to information requests, and I actually knew the answer before I got the answer officially to the committee from the department. And many of those, I filed the OPQ, an order of paper question, received a response on the same question I asked, and I got the OPQ response faster than the department was able to get it. So now I'm just worried that the questions we've asked here, and Mr. Redekop asked a question at committee just a few weeks ago, what is a test and its methods? And there was a commitment there to provide proof guidelines as that are part of the public record to the committee. Mr. Redekop had also asked about the 1,095 days. The partner confirmed some of the details to us, and then what would be the trigger point and how is the process for calculations. And then Mr. Gerard offered to provide the details to the committee. We're still waiting for those, and there's been ample time, I think, to provide them. And then I asked for clarification around do we require people to do the day counting, the utility bills to provide residency, whether it's been discontinued, whether it's only a declaration. We've gone into some detail about it. And then there was a commitment to provide with the guidelines for decision-making in relations to assessing proof of residency, which many of these amendments are impacted by that information and the administrative burden, or whether there is an administrative burden. And the last one I have here, and I have a few more, but I'll find them in my email. The next one was a question from Ms. Rempel-Gardner. Do you have a sense in the department how many people who would be affected by the sub-amendment have already applied for citizenship through another stream? The department hasn't yet responded to that. And we also have a member of the public who sent information on how many lost Canadians could be impacted. So when can the department provide the follow-ups to the information so that we can, as we go through the rest of these amendments, we can reduce the time? So there's been a bunch of questions asked by the committee. There were commitments made to provide information And I do read them, so I would like to know when will we get those responses. Thank you, Madam Chair.
Yes, Madam Chair. Thank you. I do recall those exchanges in some detail. I will continue to answer all of the committee's questions to the best of my ability as these hearings unfold, and I believe that I have provided fulsome answers wherever possible. By my estimate, I have made 2 undertakings in the hearings so far to this committee. One was to provide a number of publicly available pieces of information around the residence assessment, which the member mentioned. And that information and those links have already been provided to this committee in both official languages, I think at least a week ago. And secondly, last week on my appearance, I endeavored to obtain some statistics on the member's request with regard to applications for grants of citizenship and grants of citizenship. And that work is underway, and we hope to be able to provide it to the committee in the near future in the coming days. Thank you, Madam Chair.
Ms. Rempel-Gardner and then Mr. Reddycob.
Thank you, Chair. Just with regard to this particular amendment, I've been studying the speech history in the House, and I noticed that the Liberal speaker on second reading of this bill raised this particular issue about, and I'm just going to quote from it quickly, and I think it relates to what this amendment is suggesting. So she says, in particular, on the issue of lost Canadians, history has shown us that making hasty changes can lead to the creation of new cohorts of people that may subsequently consider themselves lost Canadians. We should ensure the legislation addresses the bigger problem and does not create a bigger issue than the one we're trying to solve. And then she speaks about how bestowing citizenship on individuals who live in another country descended from a Canadian but never sought to be a Canadian may create unintended consequences, and that the bill creates a simplified renunciation process as a result. In the context of this particular amendment, can you perhaps give us a sense of the scope of how many people might be using this renunciation process? It's something I wasn't quite clear on during the initial testimony on the bill as well, too.
Ms. Durand.
Madam Chair, yes, thank you for the question. I'll come to that in a moment. Just to clarify that this particular amendment is not dealing with a renunciation issue, though we will come to that. On estimating the number of applications for renunciation we could receive as a result of the bill, that's not something the department's in a position to estimate, because we have no way to foresee who may not be happy to be automatically accorded Canadian citizenship and to be remedied. That's a matter of individual choice depending on circumstances. Nevertheless, from time to time, the department does receive renunciation applications as it stands, and we could endeavour, in response to the member's request, to obtain those statistics and provide them to this committee, because I understood that was what the member was asking for. Thank you.
Thank you. Yes, and so again, this amendment is dealing with those who are given ministerial grants and now would become citizens under the new clauses of the bill, and confirming that their citizenship is valid. I think where I was going in trying to pull this together was, again, in the speech, there was some commentary that there already exists some provisions to deal with certain classes of lost Canadians through a ministerial permitting process. I guess, like, it just seems like with adding all of these extra amendments, to the speaker's point, there was, I think it was MP Yara Sachs, there seems to be a cascade effect here that continues to happen. if this goes through, is there anything else like that we would need to correct further on with subsequent amendments?
Yes, the member is correct that there is a cascading effect, especially when citizenship is granted automatically. In particular, on the descendants of those persons who are receiving citizenship automatically through a bill such as this one, and as indeed was the case with the remedies passed in 2009 and 2015, which is why this transition provision that's under discussion is so important, because one of the key features of it is that it's confirming that where there's a cascading effect, that any who are citizens already on the day of coming into force of this bill, should it pass, will remain Canadian citizens. Thank you.
Before we proceed to our next member, Mr. Redikop, on behalf of all the members, I would like to wish our colleague and friend, Mr. Al-Khouri, a very happy birthday. Hope you have a great day. We will go to Mr. Redikop now.
Well, now I'm expecting some sweets. Where's the sweets? There should be some sweets here. Okay. Madam Chair, I just want to come back to the documents that Ms. Girard said were sent to the committee. I don't think I received those documents, and I don't know if something got missed. I'm just wondering if you can maybe check with the clerk and see, confirm which documents, because I don't recall the documents unless I'm confused.
Okay, Ms. Girard.
Yes, my apologies, Madam Chair. I thought I had it. I thought they had been provided, and I misspoke. So that's on me, and that's on our side. But we will go back and check where they're at so that they can be provided to the committee at the earliest opportunity.
Thank you, Ms. Girard.
Okay, that's...
Mr. Redikop?
Thank you. That's helpful, because I was confused. Not that I'm always confused, but yeah. I guess the other question I have for Ms. Girard is on the numbers. When you were just responding to my colleague, Mr. Rumpel-Garner, did you say, I just want to make sure I got this right, did you say that you cannot come up with numbers to estimate the impact of this bill? Is that what you were saying again? Because I know you've said that in the past, and I just want to make sure that's what you're saying.
Thank you. Yes, I was referring to the question about persons who may wish to renounce Canadian citizenship on receiving it automatically. And so my comment about not being able to estimate in advance how many people impacted positively by this bill may then find themselves in a situation of wanting to relinquish it, that's difficult to say.
Mr. Redikop?
All right, I get that. It's difficult to do. I would acknowledge that. Prior to coming here, I worked as an accountant for many years, working in finance, different roles. And one of the biggest projects we always had to do was budgeting and forecasting. If we design this product, what's the impact going to be? What are the sales going to be? So there's always tremendous unknowns. And so I just don't accept that you don't have some grasp of that. And obviously, it's a forecast, it's a guess, with all of these caveats that go with it based on these assumptions and all that sort of thing. But I just find it strange that the department hasn't actually sat down and said, well, it could be anywhere from here to here or whatever. And so has any of that been done, or are you telling me that that's just a straight up no, we haven't done any of that work?
Madam Chair, as I've indicated when asked this question before by the committee, we've estimated that in terms of the two main groups that the bill is addressing, or that the bill and the amendments to the bill thus far are addressing, in terms of the numbers that the department estimates would be addressed by the remedy for the lost Canadians affected by Section 8, it's a limited cohort. As I've mentioned before, the department sees in the range of 20 to 30 such cases per year. And so, there may be a few more who come forward benefiting from this bill, but it could be in that range. With regard to the remedies extended through the amendments to the bill discussed thus far in terms of the extending citizenship automatically to second-generation children born abroad to a Canadian, we estimate that number could be significantly larger, in the thousands. But as I have mentioned before this committee, it's difficult to know how many of those may actually come forward to the department and request a certificate of the Canadian citizenship, because the bill, as amended, if passed, would make them citizens automatically by law, and so citizens in law. And so those who elect to come forward to apply for the proof would be a subset of that, those untold thousands. And I guess the third point that I would mention to wrap up is for the past legislative remedies combined, for the remedies in 2009 and 2015, for lost Canadians, our updated figures, as I have shared with the committee before, are just under 20,000 such persons have come forward for a proof of citizenship in the past. So, you know, it's conceivable that we could be dealing with numbers in the range of a few thousand up to that number, but until we see in what form Parliament decides to legislate and pass a bill, it's difficult to know with any precision. But those are some of the orders of magnitude that we consider not unreasonable. Thank you, Madam Chair.
And just one simple clarification. So when you say thousands, you're talking per year? Is that what you're meaning?
Yes, that's correct.
So I just have questions about the numbers now, just so I understand, because you use hundreds and then you use thousands. When you were talking about hundreds, whom did you mean? And was it annual or total? And when you're talking about the thousands, did you mean total or did you mean annual?
Madam Chair, in each case, my remarks with regard to the Section 8s, as we see 20 to 30 such cases per year, and with regard to those who could receive citizenship automatically where a parent is meeting a connection test, that could benefit in the thousands, again, per year. Thank you.
So then I was going to ask, on May 1st, though, there was a number used, 40 to 60,000. That means the total expected persons who could be impacted by S245 the way it's originally written, or based on the amendments we had done until then? Or is that the total lost Canadians? I guess it could be three different options.
Ms. Girard?
Madam Chair, that's a different number. It's because we were having an exchange at the time, about the number of persons currently who apply for a proof of citizenship annually. And as a frame of reference, I gave that 40 to 60,000 annual number in terms of the number of such applications the department already receives. And so these numbers that we're discussing at this moment would be over and above those. Thank you.
So has the department ever considered using an outside, expert to come in and estimate, depending on what the changes are that are on the public record so far versus what's before, to provide an estimate to the department on the potential workload going into the future? Like somebody who just crunches numbers, that's all that they do based on whatever input you provide them.
Ms. Girard?
Madam Chair, no, we have not sought or considered outside help. But we do have our own folks who crunch numbers, as the member referenced. And as I mentioned before, you know, even if we may estimate that several thousand per year may come forward and make applications under this bill, if it were passed by Parliament, there can be a bit of a tendency at times to overestimate the numbers that we may see, particularly when we consider that since the first set of comprehensive remedies in 2009 were passed, and that, you know, up until around now, just under 20,000 persons have come forward since then who benefited from those previous amendments. it's a good number, but I don't think anyone would say that that's a huge number by any stretch when you consider that we receive 40 to 60,000 applications for proof of citizenship per year. Thank you.
So just the committee received a letter, and I want to make sure I credit this person, Carol Sutherland Brown. So we got information, actually we got some numbers being provided. There's this court case going on right now. The co-counsels, this is before the Ontario Superior Court of Justice, and I can't pronounce the name, Bjorkquist et al. Versus AG of Canada. Hopefully I pronounced that correctly. And the co-counsels are Sujit Choudhury and Ira Pargi. Referred to such data prepared by Dr. Doug Norris, a highly regarded retired senior Statistics Canada executive. I didn't know that he worked there, but I trust the data. And it goes on to the methodology. The group that they identify here, and they use Statistics Canada data, they're using 2016 from what I could see. And in it they have a low, a medium, and a high. And their numbers are drastically lower, actually, than the numbers that you've provided so far. It might be just the way that they're calculating it, like whom would be impacted, because they have here, even by the highest estimates, by 2045, the numbers of children born abroad to Canadian parents would still be only just over 1% of the total number of immigrants than the government claims we need. These numbers would represent only approximately 0.01% of the total population of Canada. These numbers do not represent a floodgate by any means. Those are her words. And at the beginning there, the parameters of the estimation, I guess, she was trying to address the concerns some of us have expressed at the committee. She has here, by several MPs, that a change in legislation would give rise to a potentially increased workload for IRCC officials, and that there would be a floodgate of many thousands of applicants. The numbers they provide here by 2049 at the max, at the absolute maximum, is 7,000. At the low end is 234, and kind of a reasonable, I guess, future. I would use 2030. They thought it would be 3,877 as a pool of potential applicants to it. Do you think those numbers are credible or reasonable, like as compared to the ones you've provided? They could be like a low point, or do you feel that IRCC's numbers are better because you have more informed data? Like, I just would like to know, because this is evidence that's been provided to us by a member of the public, and this is part of a court case, so I just assume that it's credible if the judge accepted it.
Madam Chair, I really can't comment on the validity of the methodology used in the example that the member has provided. Nevertheless, I would sort of propose to this committee or remark to this committee that I have made the point that since 2009, just under 20,000 people who were remedied by previous Lost Canadian legislative remedies have come forward since that time. And that does suggest that the numbers, while in the thousands, could be manageable. And I've also provided the estimates that for the Section 8s who could benefit, it could be in the range of 20 to 30 a year, or it could be more. And with regard to the second generation children born abroad to Canadians, that it could be in the thousands, but it's difficult to know the range, and it may not be a huge number. So I think that in terms of the point that the member is making, that I'm not sure I particularly like the term of floodgates, but I think that's consistent with the point that I've shared with the committee, that there is a risk to overestimate what the numeric impact would be. Thank you.
So yeah, I don't like the word either, but that's the word that was used in the communication with the department. They provided actually a link to it. There's an estimation model in the Excel workbook with all the source data, the assumptions, the calculations used, and handily they also provide a password so we can open it and play around with the methodology. Is that something that, are we able to provide that, Madam Chair, to the officials if they wanted, like that link? This is a public document, is it not, as a brief provided to committee by a member of the public?
If you would like to provide it to the officials.
Well, it's been provided to the committee as a brief, so I assume it's public information then?
yes. Yeah.
So I just think it would be highly useful because in the details, Dr. Norris then provides a breakdown of the methodology, and I'm not going to go and read the whole thing, but just like the steps that he took, estimating in different worksheets the total number of persons could be impacted. There are multiple steps. I mean, there's step 5 with multiple sub-steps just to get at the diaspora group that could be impacted by this, just as a total amount, and then kind of working backwards on how many persons might want to apply into the future. And it goes into a great deal of detail trying to estimate those numbers. So we've asked that information from the department, obviously. I just think this would help us get to an actual number that we could find, defensible. And if it is as low as this table says, which, like I said, it was 7,031 on the high end, and as low as just a few hundred people on the low end by 2049, then we're not talking about a large group of population. We're talking about a very, very, very small group of people that would be impacted. And that potentially you could use this worksheet in the future when estimating other groups of lost Canadians that could be covered off by other pieces of legislation. So I just think it's an opportunity. And like I said, there's this court case going on right now where all this information is being considered. So, I mean, it was provided to them. So I hopefully we can have the officials deal with it then. That's all I wanted to say, Madam Chair.
I think sometimes if you read the whole document, it will help you further as well.
Do you want me to read into the record,
I
Souk?
mean, it will
En
help
français
you
ou en
guys.
anglais, ou tu préférais?
Request members to have conversations through the chair.
Yes, Madam Chair.
Ms. Lalonde, you raised your hand. Okay, thank you. So seeing no further debate on G5, I will ask the clerk of the committee to please take the vote on G5.
Mr. Ali,
In favor?
Mr. Dhaliwal, Mr. El Khoury, Madame Kayabaga,
Pour.
Madame Lalonde,
Pour.
Mr. Kimich,
4.
Mr. McGuire,
4.
Mr. Redekop,
4.
Ms. Rempel Garner,
In favor.
Mr. Brunel Duceppe,
Pour.
Ms. Kwan.
For.
Yeas 11, nays 0.
Thank you. We will now proceed to NDP. Yes, Mr. Brunel Duceppe.
Oui, je veux juste vérifier si...
I'm trying to check if my microphone is working. Is it working? Okay. I'm missing a wire, but okay.
Thank you. We are on NDP 4 now. So, Ms. Kwan, would you like to move it? Yes, Ms. Kwan.
Thank you very much, Madam Chair. Yes, I'd like to move NDP 4. This amendment essentially recognizes citizenship in deceased women who lost British subject status prior to 1947 or in 1949 in Newfoundland and Labrador. And on that basis, they did not become citizens. Citizenship is recognized retroactively to the time each woman lost status as a British subject. This amendment does not allow for derivative claims, and there is no liability to the government. And noting that Section 11.2 of the Citizenship Act provides for citizenship for such women if they are still alive. So accordingly, the amendment only covers women who are deceased. One may ask, why is this even necessary? Because for some family members, that is important to them. In fact, I met with somebody whose dying wish, actually, was to have been recognized, an elderly lady. In any event, I think this is important just for symbolic purposes, Madam Chair.
Thank you. Mr. Redekop?
Thank you. So I guess my question on this for the officials is, number one, maybe let's start with this. Do you have any concerns about this amendment from your perspective as a department?
Ms. Girard?
Thank you, Madam Chair. The first sort of point I'd like to share with the committee is that to this point, none of the previous legislative remedies for lost Canadians in either in 2000 or 2015 restored citizenship to persons who had passed away. So that is a first concern. The second concern is just that is a concern about the potential for unintended consequences, including potentially for citizenship by descent for such persons. I believe there is a provision in the proposed amendment that is seeking to mitigate that. But from the perspective of the experts here in the department and our colleagues at the Department of Justice, were not necessarily convinced that that concern is fully mitigated. And so there is a concern or potential for unintended consequences or impact on the citizenship by descent of the descendants of those who are targeted by this amendment. And those are people who are alive today. And so those are some points to share for the committee's consideration. I'll just invite my colleague from the Department of Justice in case there's anything I've neglected or there's anything that she may wish to add on this point. Thank you.
I would just echo my colleague's comments just now and say it's, of course, open to Parliament to legislate retroactively, but it is inherently complex because we're talking about applying new laws to facts that have occurred in the past. So particularly if we're talking about a period of time, some 80 years in the past, it's very difficult to say precisely what the consequences might be. And in particular, in this case, with the legislation that existed prior to 1947, to know exactly how these amendments might interact with legislation from that time period, it's difficult to say with precision. Thank you.
So that's good because I was thinking some of the same things. But this last point, Ms. Schneidereit, did I say that right? So how does that actually work? Because the legislation obviously would have been much different back in those days. So how does it even interact? How does that work from your perspective?
Thank you for the question. I mean, I think I would just say, again, it's very difficult to say with certainty. What I can say is that, in general, with legislation on citizenship or nationality, there's typically one scheme that operates. Nationality is sort of one thing, right? So if we have two different pieces, it would be somewhat novel, I think, to try to predict how those two pieces interact. So at this point, it's difficult to say. Thank you.
So I guess back to Ms. Gerard's two concerns. So the first one you mentioned about we've never legislated anything on people who are deceased. Now, was the consequence of that your second point, or was there further consequences? Like, are there other things that brings up? Like you talked about the unintended consequences of descendants, because that was going to be my other question. But just on the issue of issuing citizenship to a deceased person, other than the unintended consequences of descendants, are there other issues that would potentially bring up?
Ms. Girard?
I think that the member is correct in the sense that the main concern is one, to limit or avoid unintended consequences. And as was brought up moments ago, one of the important ways to do that is to offer a mechanism for those who may need to renounce for personal, professional, legal, other reasons, as soon as a legislative remedy like this comes into force, and where the beneficiary is not alive to do that, the option isn't available, and then it can have those downstream automatic kind of trickle-down impacts on the children who may now be adults, particularly in this cohort that's under discussion, where we're talking about women who, we're talking about a pre-1947 cohort. But again, I'll turn to my colleague at the Department of Justice who may wish to further elaborate. Thank you.
I think that mostly covers it, but just to say perhaps that the Act, as it's structured currently, envisions citizenship attached to living persons. That's all I'll add. Thank you.
So just on that point, could this potentially complicate legal issues then because of this new interpretation if it were to proceed of both living and deceased persons? Does that really throw a bunch of complication into court proceedings and common law and those kinds of things?
Yes, I think it would. And I think the other concern that we have in the department, and that I understand the Department of Justice shares, is that we may not fully know the legal and practical consequences unless, a provision like this passes. And so we want to ensure that the committee is aware of these concerns and considerations, that it hasn't been done before. And I will, again, pass it to my colleague in case she wishes to add.
Nothing to add. Thank you.
So then on the issue of the descendants, because that was the first thing I thought of when I looked at this. So we don't know, or you're saying that there is some wording in this amendment to prevent that, but you don't necessarily think it's sufficient to eliminate it? Could you expand a bit more on why you think that?
Yes, that's correct, but perhaps my colleague could elaborate.
I would just perhaps return to my earlier point on this issue of the interaction between the current amendments and the previous legislation to say, that sort of being an unknown, it's difficult to say, again, for, say, descendants of those persons, how they may be affected. Thank you.
Thank you. Ms. Kwan?
Thank you very much, Madam Chair. Not to prolong further debate on this, because I know that this likely would not pass. But just to put it on the record, in terms of what the Legislative Council has provided by way of language to ensure that there are no implications, legal or otherwise, in this amendment, included in the language is subsection 7.1, which is the provision that says to recognize citizenship for this group of women. It says, does not have the effect of conferring any rights, powers, or privileges, or imposing any obligation, duties, or liabilities under any act of Parliament or any other law on a woman referred to in that subsection or on any other person who may have any of those rights, powers, privileges, or obligations, duties, and liabilities as a result of the woman being deemed to have been a citizen. Then it goes on to add another clause, 8.2, for greater certainty, no person has a right to citizenship as a result of any woman being deemed under subsection 7.1, which is the section that I would like to add, to have been a citizen. Then it goes on to say no action or other proceedings for damages based on subsection 7.1 may be brought against Her Majesty in right of Canada or any other officers, employees, or agents of His Majesty in right of Canada in respect of anything done or omitted to be done. Anyway, that was the certainty that the Leg Council had suggested that we incorporate into this so that there would be no implications coming out of this. So in any event, I understand that perhaps people still feel that that's not enough. But it is not done without consideration on those elements, Madam Chair.
Thank you, Ms. Kwan. Seeing no further debate, Mr. Kimmich?
That's something I was going to ask about, but because it's my fourth question, I was just wanted to ask on that, just so I understand, you saying it's never been done to legislate backwards like this. And I was going to ask, is that even like, say it were to pass and say this were to become the law, is this even defensible in court? Like, how could a court say that you get you get citizenship, but you have none of the rights of citizenship? That's the way I read that clause that was just read by Ms. Kwan, is that basically give citizenship, but it basically confers no rights, powers, or privileges, no obligations, duties, liabilities. It's like you have it, bless you, you have it, but it gives you nothing. Like, has that ever been done? Is that even defensible in court?
Madam Chair, in layman's terms, I would explain the department's concern as being, while the intent of the language that was read is good, we are not satisfied either in the department or our colleagues in the Department of Justice that these provisions intending to serve as a mitigation are actually ironclad, if I can put it like that, that they're doing what they're intending. And I therefore completely understand the member's question, but I certainly don't want to speculate about what kind of future defense the government may wish to prepare or put forward for such a case. Thank you.
So I don't want you to speculate on it. I'm just wondering, like in case law, like a section like this, if I were to clip it and use it in the future, or if it were to be added to any other amendment before the committee, like, can we give people citizenship or a right or a grant to citizenship and then say, but you don't have any of the benefits of citizenship? Like, that's the way I read this, that it would cause basically a person to have it, but have none of the benefits of it. Like, the citizenship by right or by grant means something. You have the right to vote, you can stand for public office, you are expected as a duty to pay taxes, you pay into, when old age security was created, when the Canada Pension Plan was created, you pay into it, you have a right to those things you pay into. But this would basically imply that you are a citizen, but you don't have any of those rights. Like, and potentially a section like this could be applied for any group of lost Canadians out there where they get the benefit but don't have it. So I'm just wondering, like, is this something that's ever been done before? And in the legal opinion of the Department of Justice Canada, like, is this even defensible? Okay, to me, this looks like a judge would knock it down immediately. I don't see how you can give someone citizenship but say you have none of the benefits of citizenship. Or am I wrong?
Well, Madam Chair, I think it sort of comes to the point that there's not any precedent for this, as I mentioned, in the sense that none of the previous legislative remedies accorded citizenship to persons who were deceased. And so this issue hasn't arisen in terms of the question that the member is raising. I don't have any experience to draw on there. Thank you.
So I'll move on to my other questions then, 'cause I got the response I think I needed. Do we have like a register or information on like this term war brides? Like how many women, I guess pre-1947, would have married but then lost their citizenship because, or they're by these rules here? Like, I'll be completely honest, I did not know this was something that was occurring. So pre-1947, right, there was no Canadian Citizenship Act. So do we have a register? Does the department have such information? Is this information that Veterans Affairs would have, or Archives Canada, or is just information that was never kept centrally? This is from a different era?
Madam Chair, no, the department does not have a registry, but what we do have are some actual statistics. And that is, as the member was mentioning, the legislative remedies in 2015 who were benefiting some additional lost Canadians did benefit women who, before 1947, married a foreign national and lost their British subject status and therefore did not become citizens on the 1st of January 1947 as others did. And so I believe that the statistic I previously shared with this committee was that roughly 600 persons who benefited from those changes in 2015 came forward and applied for a proof of citizenship. So we do have that figure, but in terms of this particular amendment that's under discussion now, with regard to people who are deceased, we wouldn't have any way to quantify that kind of number. Thank you.
Because I don't know what the rules were like before 1947, is there any chance this might create like two types of persons pre-1947 who, like, on top of the ones treated? So there's a group of them who may get it back, but it will be based on, this is basically everyone, correct? Like, it's just a broad stroke, everyone gets it back. These are all persons who are deceased. They would get nothing extra, but is there any potential for creating two groups of people where a person could have, and although it would have been very rare, who would have been either widowed or divorced at some point, but still before 1947, where they would have gotten back, but then would have fallen through the cracks? Like, is there potential for that, where some would have received, some will get it back if this amendment passes, but some would still be excluded in the very off chances? Is that possible in this? Like a different group of lost Canadians or a subgroup of lost Canadians?
Madam Chair, I think the potential is there, just by the way that the amendment is selecting out a particular cohort. It's referencing women who lost their British subject status prior to 1947. And we are speaking of people who are deceased. So we're not talking about any other deceased at other points in time, men, for instance. So I would say that the member is correct, that in general, this amendment is looking to accord citizenship to some persons who are deceased and therefore didn't become Canadian citizens, and not others. Thank you.
Okay, so just on this classification, that basically confirmed that it could be a smaller subset that would become, that would still be non-citizens of Canada. Just on the latter sections of this amendment, because it's quite a long one, the subsection 8.2 and 8.3, it says here, for greater certainty, no person has a right to citizenship as a result of any woman being deemed under subsection 7.1 to have been a citizen. Can someone just explain to me the impact of this particular section?
I'm going to ask my colleague from the Department of Justice to comment. Thank you.
I'd just say my understanding of the amendment is that it's related to the derivative claims. I said that it's related to derivative claims, but that's my understanding. I'm not confident. Thank you.
I am not burdened by a legal education, so please help me out. Derivative claim, what does that mean in this context?
I think the question about Section 8.2 would be related to claims to citizenship by descent, the way it's currently worded, but I think it would be a question for perhaps the NDP member. Thank you.
Okay. Okay, well then my next question is on 8.3, which is the next subsection, because it indemnifies the Crown for any potential litigation, but if you read the previous one where it says there's no rights, powers, or privileges, obligations, duties, I understand this is like it's to give it but without any benefits associated with it. This section indemnifies the Crown, does this occur in other parts of the Citizenship Act or the IRPA? Like, is it a standard section to indemnify the Crown in case litigation could happen? I'm just asking, like, is this consistent with other language used? Has this happened before? Would this be something unique to be introduced into the Act?
Ms. Girard?
Madam Chair, thank you for the question. There is similar language that was included in the previous legislative remedies in 2009 and in 2015, though I can't say at this moment whether the language is the same or might be slightly different. Thank you.
Thank you. Just a small detail. I don't know if it is a really small subset, I would say, but my colleagues have been speaking about war brides, and you've mentioned this as well. And we're talking about pre-1947. What about persons or women that came from Britain at that time living in Newfoundland, which didn't become a province until 1949? Is there any difference in there? I'm assuming that they would have kept their British citizenship when they landed in Newfoundland, whenever, as war brides, if they did, or were they considered war brides if they were living in Newfoundland and not part of Canada at that time? And therefore, then would there be a change, or were they just all Canadian citizens with everyone else when Newfoundland became a province?
I'm sorry, Madam Chair. Could I just ask the member to repeat the last part of his question? Thank you.
Yeah, I'm just wondering when these war brides came, and we will call them that, and everywhere else in Canada they would have been. I'm assuming that the same term applies to those who came to Newfoundland pre-47, as we did in Canada, but there's that period of time between 47 and 49 when Newfoundland wasn't a province yet. Would they all become citizens of Canada when Newfoundland became a province in 49 automatically?
Yes, that's my understanding, Madam Chair. Thank you.
No, that's my only question.
The debate, we can take a vote on NDP 4. If I can ask the clerk to please take the vote. We will be voting on Mr. Brunel Duceppe.
Non, c'est parce que je suis vraiment désolé.
I'm sorry. I have a question that came to mind. If, with regards to the amendment, if ever Quebec becomes a country tomorrow morning, does it change anything? Thanks.
Merci, Madame la Présidente.
Thank you, Madam Chair. Given that the amendment targets people who lost a British status before 1947, I'm not convinced that it would have an impact on people mentioned by the member. Thank you.
Thank you. Seeing no further debate, we will take the vote. I will ask the clerk to please take the vote on NDP 4.
Mr. Ali.
Against.
Mr. Dhaliwal. Monsieur El Khoury. Madame Kayabaga.
Contre.
Madame Lalonde.
Contre.
Mr. Comich.
Against.
Mr. McGuire.
Against.
Mr. Redicott.
No. No.
Ms. Rempel-Garner.
Against.
Mr. Brunel Duceppe.
Contre.
Ms. Kwan.
4.
Yeas 1, nays 10. Yeas 1, nays 10.
So NDP 4 is defeated. We will now proceed to NDP 5. Ms. Kwan, would you like to move? NDP 5.
Yes, thank you very much, Madam Chair. Yes, I'd like to move NDP 5. This amendment deals with a number of the issues, and particularly I want to highlight the issue around for those who don't want citizenship conferred to them. There was quite a bit of discussion, committee members will recall, about that concern. What happens to those who don't want it for whatever reason? And so to that end, written into this amendment is the opt-out opportunity. For those who don't want it, they could opt out. So it would be as though that upon notification to the government that they don't want citizenship conferred to them, then this would have no impact for them. This would not apply to them. So effectively is an opt-out provision. So, and that's what it's aimed to do, Madam Chair.
Ms. Lalonde?
Merci beaucoup.
Thank you very much, Madam Chair. On this, I would like to move 2 amendments. I will go one at a time to facilitate our discussions. Might the interpreter have a copy of this, please? On the first,
I believe the interpreter has just asked for a copy of the amendment, if possible, Madam Chair.
Sorry, 1 second. Ms. Rampelgarn, what did you say?
The interpreter just asked for a copy of the amendment, if possible.
Ms. Lalonde?
yes, I'm sorry. I believe that my colleague might have read NDP 8 instead of NDP 5. Is that possible?
Ms. Kwan, can you please read it? I think the whole, yeah, if you can read it so that everyone is clear which one we are on.
Okay.
And we are on NDP 5. If you can please read it.
All right. NDP 5 reads as follows, that Bill S-245 in Clause 1 be amended by adding after line 18 on page 1 the following. 4 Section 3 of the Act is amended by adding the following after subsection 7.1. Despite any provision of this Act or any Act respecting naturalization or citizenship that was in force in Canada at any time before the day on which this subsection comes into force, a person is deemed to be a citizen under paragraph 1B from the time that they were born if A, the person is a citizen under paragraph 1B, B, the person was born after April 16, 2009, and before the coming into force of this subsection, and C, at the time of the person's birth, only one of the person's parents was a citizen, and that parent was a citizen under paragraph 1B, C.1, E, G, H, O, P, Q, or R, or both of the person's parents were citizens under any of those paragraphs. 5, Section 3 of the Act is amended by adding the following after subsection 8.1 for any period before the day on which subsection 7.1 first takes effect with respect to a person. Subsection 7.1 does not have the effect of conferring any rights, powers, or privileges or imposing any obligations, duties, or liabilities under any act or parliament other than this act or any other law on the person or on any other person who may have any of those rights, powers, privileges, obligations, duties, and liabilities as a result of the first person becoming a citizen.
Merci beaucoup.
Thank you. Once again, on the NDP 5, I would like to move 2 sub-amendments or 2 amendments, of which the interpreter has no copy. So, yes, that's what I just said. I'm going to introduce one, then the other. The first amendment would be that NDP 5 proposing the modification of Clause 1
the amendment and
Yeah, excusez-moi.
and I can't follow, and this seems
Okay,
to be a
I'll
very
ask.
technical amendment, and I would like to know what I am voting on. Thank you.
No problem.
This is the interpreter. Could it be possible to get a copy of this? Hello, this is the English interpreter. I have no copy of what this French text that she's reading. Is it possible for me to obtain a copy of this, please?
Do you have a copy? I'll just suspend the meeting for 2 minutes to figure out where the copy is. So the meeting is suspended for 2 minutes.
Thank you very much, Madam Chair. I apologize. I think I might have confused committee members. I should have actually followed the notes. Instead, I followed my own handwritten notes, which was wrong. So this is actually not to deal with the opt-out provision. That's another amendment for another time. But this is dealing with the package in relation to the second-generation cutoff rules that have been dealt with previously. And specifically, this addresses the retroactive to birth and no liability issues for citizens related to this, and that there would be no consequences or duties, for example, back taxes and those kinds of things. And then finally, it does allow for, which is a current practice in any event, that if the government, if the people wanted to challenge the government, as they are right now in court, they would be able to do so. So I apologize for the confusion, Madam Chair.
Thank you very much, Madam Chair. And again, I do have two amendments, and I'll go one at a time. J'aimerais propose.
I would like to move that motion NDP 512307559, proposing to amend Clause 1 of Bill S-245 by adding text after line 19, page 1, be amended by substituting the following for the text of the proposed subclause. 3.1 Section 3 of the Act is amended by adding after Section 3 of the Act is amended by adding the following after subsection 6.2, semicolon, 6.21, a person who is deemed to be a citizen under paragraph 1b from the time that they were born solely by operation of subsection 7.1, and who, before coming into force of this subsection, comma, was granted citizenship under Section 5 or 11 is deemed never to have been a citizen by way of grant.
For amendment to the NDP, the first of two. And I would like to give some explanation because I know these are extremely technical and complicated. So I just want to, just to make sure it's clear, the NDP amendments aren't referring to the same cohort of people that the government amendment touch. In the government's amendment, we're talking about the former Section 8s, who were second generation born abroad before 1977 and 1981. The NDP amendments address the situation for children born abroad in the second or subsequent generation after 2009, including those who will be born in the future. So NDP 5 describes what happened for children that were born abroad in the second or subsequent generations since April 16 of 2009 and are already alive when this bill passes. So if they have a parent who met the connection test prior to their birth, these kids will become citizens. This amendment addresses a similar issue, some amendment addresses a similar issue as the one we talked about in Amendment G5. In this case, it's the situation where a child born abroad since 2009 had received a grant of citizenship at some point in their life because they immigrated or got a special grant, but now is able to have automatic citizenship because this bill. This sub-amendment clarifies that someone in that situation is now deemed to have never received the grant and is now considered a citizen by operation of law from the time they were born. Merci, Madame la Présidente.
Thank you, Madam Chair.
Thank you, Ms. Lalonde. Mr. Brunel de Sepp.
Oui, j'ai une question.
I have a question for the analysts. It might be more relevant than my previous question. So we're very hypothetical ever since the beginning. We have no choice. Oftentimes, we're asking questions on hypothetical cases that might come up.
Excusez-moi. Excusez-moi, je me suis trompé de mot.
Sorry, I used the wrong word. It's for the officials. So if we pass the bill as it is presented with amendments and sub-amendments, here's a hypothetical case. Let's say that in 2028, Quebec accepts sovereignty. Would this mean that the next two generations of Quebecers now living in another country would then become Canadian citizens, despite that they would not have been born in Canada? So would it mean that these people, for two generations, could then, as expats with Canadian citizenship, could vote in Canadian elections? It's a hypothetical case. I'm just wondering, if I'm looking at this now, I say, well, if Quebec becomes a country tomorrow morning, the next two generations of Quebecers would then become Canadian citizens and could even vote in Canadian elections. It's just a question I have.
Merci.
Thank you, Madam Chair. It's an interesting question, and I'm sorry because I can't give you any specific answer. We would have to delve further into the facts and the different legal dispositions that could enter into play and do a more in-depth analysis to try to respond to this question for a type of this type of scenario that's been laid out. Thank you. Yes, but it would be clear. You're born in a foreign country of Canadian parents, and your children would be born in a foreign country. The second generation would be also born in a foreign country. But so logically, if we follow the Act with the changes, with what we have here in my hypothetical case, this would be confirmed unless there would be some type of agreements. But right now, my hypothetical case allows me to say this, right? Did you have a question in that? Did you have a question for officials?
Is there any clarification you are looking for, Mr. Brunel de Sepp, or just
Non, mais on me dit que...
No, but I'm told that they can't tell me if I'm right or wrong, basing oneself on this hypothetical case and what we have to vote on. I thought it was clear, but apparently no. I don't think we find it clear. That's all. Thank you, Madam Chair, but I think it could be an interesting thought process for my Federalist friends.
Question?
I don't have anything to add. Okay. Thank you, Madam Chair.
Thank you. Mr. Dhaliwal?
Madam Chair, I have a bit of a difficulty with this. If sovereign Quebecers want to separate and they want to have their own country, and why wouldn't they now they have the Canadian citizenship? And my dear friend Brunel de Sepp is asking if they will be able to vote in Canadian elections, so might as well stay with Canada. Or I can tell you, Madam Chair, the chances will only improve if Mr. Brunel de Sepp becomes the leader of the bloc and he can progressively and exclusively work with other people.
Juste pour répondre rapidement, en tout cas...
To respond quickly, it would be really interference. That would be political interference. So no, thank you, Mrs. Chair.
Mr. Reddycop?
Okay, so this amendment, so I guess my first question is, just so that I'm tracking here, so that this sub-amendment goes before anything that is in NDP 5, and it doesn't delete...
This is an amendment. We don't have any sub-amendment. We have amendment on the floor.
Sorry. It's
The amendment, so like, okay.
It's a sub-amendment.
To G, NDP 5 and then sub-amendment. So, okay, sorry for that.
Okay.
Yes, sub-amendment.
See how confusing this is? Okay, so the sub-amendment to NDP 5 comes before any of the text in NDP 5 and doesn't delete any of NDP 5. Am I correct in that statement?
Can you please repeat?
So the sub-amendment comes before any of the text of NDP 5, but does not actually delete any of the text of NDP 5. Correct? Okay.
Ms. Lalonde?
You are correct.
Okay.
Mr. Bedico?
Thank you. So this is always difficult without actually understanding what NDP 5 does to try to understand what the amendment does. So I guess maybe if you could, I don't know, if this is maybe for the officials to tell me and the committee what exactly this is doing and why it needs to be there.
Thank you, Madam Chair. These proposals once again fall into the category of what we would describe as a transitional type provision. It's technical, but it's important that it be there for the department to be able to implement it correctly and in line with previous legislative remedies. And so our understanding is that the NDP amendment, as shared, is intending to clarify that those in the cohort who are benefiting are receiving Canadian citizenship back to the date of their birth, not to the date that a bill comes into force, first of all. So, and then the element that's added by the sub-amendment that has just been shared is also to clarify that for those who are receiving automatic citizenship back to the date of their birth, if they had already been granted Canadian citizenship, it's as though they've never been granted citizenship. They're considered automatic citizens from the date of their birth. So it's undoing the grant of citizenship, if I can put it that way. And that is a transitional provision. It's important that it be there, and it's also consistent with the legislative remedies that were done in 2015 and 2009. And it's so that the department, when we receive a request for proof of citizenship, we can process it correctly, and we know that we're dealing with someone who's a citizen from birth. We're no longer dealing with someone who was at some point granted Canadian citizenship. Thank you.
Okay, so this sub-amendment is only needed if the amendment passes. That's a fair statement, correct?
We will be first voting on the sub-amendment and then going back
Understand.
to the amendment as amended.
But I guess maybe to put it a different way, this piece of text here isn't needed for any other reason in this discussion today other than if this NDP 5 passes. Is that a fair statement?
Ms. Girard?
Madam Chair, yes, to a point. But again, these provisions we could consider them as transitional provisions that are necessary for consistency with past legislative remedies that were done in 2015 and 2009, and to treat like cases in a like manner, and so that we are able to treat these legally as persons who are citizens from the time of their birth, and consider them never to have been granted citizenship if they were at some point in time. Thank you.
I think that's it for the moment.
If this sub-amendment doesn't pass, what would be the impact? If the amendment passed as is without this sub-amendment, what's the impact?
Madam Chair, it's not a desirable situation for the department to find itself in terms of administering if the bill becomes law, because there would be a lack of clarity, especially with regard to those individuals who may be benefiting and becoming citizens automatically, who've already been granted citizenship at some point in their lives. It could lead to confusion, and it is desirable to have a clear legislative rule similar to what the other legislative remedies done in 2009 and 2015 contained, in order to facilitate the administration of and the processing of the proof applications, which would come in future should this bill pass as amended. Thank you.
But, sorry. Yeah, so just to follow up on that, so if this doesn't pass, is just an administrative burden, or is it a legal question whether a citizen who got a grant of citizenship and now is automatically by right a citizen, whether those two conflict, they basically get an extra citizenship number? Like, or is that the problem? Or is it a question of when did the benefits of citizenship accrue to them? Like, would there be an impact on things like CPP, OAS, and these types of questions? I'm trying to understand what the issue is here with this sub-amendment.
Yes, the member is correct. It's both a legal question and a question of administration, and the law needs to be clear in order to avoid any kind of unintended or unforeseen questions or consequences, such as the example given by the member, and also for consistency with the current scheme of the legislative act. The current scheme of the legislation, you are either considered citizen as of right, as we've discussed in the committee, or someone who's been granted citizenship at some point. You can't be both. And so we need this transitional provision in order to kind of reconfirm, if I can put it that way, that you can't be both, and that if you're benefiting from the bill and you had previously been granted that grant, it's as if it had never happened. You are a citizen as of right, and you are a citizen from the time of your birth, so that it's clear. There's no risk of confusion. There's no risk of unintended consequences for the person, and the department can clearly administer these provisions. Thank you.
So you used the word can't be a citizen by grant and by right at the same time. Is it a can't? Because in the Citizenship Act, as far as I know, I don't think it says that. Is it just the interpretation of the department that you can't have it both ways? I don't know. There's only two ways to get citizenship, right? So, like, is it just like that's the problem? Because the Act doesn't say you can't have it. Get it to it by either way. Would it just cause, like, it just seems like it would just cause confusion, but there's no, like, nobody's going to go to court to fight this out, like, or a government department wouldn't deny someone a service or the right to a pension because they got it by grant versus by right, except for the timelines. Like, because the latter part I understand. Is the issue just the timelines? Because I can't understand how, like, where you could find yourself as a Canadian citizen, having received citizenship from either path, that you find that there's an issue when accessing a service or a government product, provincially or federally. Like, I'm trying to understand where the issue will be, because I don't see that in the Act or any of the other sections of this of the total amendment. I don't see where that issue is. I'm trying to understand whether to vote for or against the sub-amendment.
Yes, Madam Chair. The legislation sets out in Section 3 different circumstances or categories of ways that people are Canadian citizens, and people become Canadian citizens under a separate section of the Act, Section 5. And so, as I've mentioned, you're either one or the other. It's under the legislation as it currently is. It's not possible to be both. But in practical terms, the member is correct. The timeline is very important. And I can share with this committee that when I was working on preparing for the implementation of the 2009 legislative remedies, I did have persons in the provinces, I forget which ones, contact me with regard to, soon after the implementation, on live cases to say, do I understand from this person that we're working with that they are a Canadian citizen? They say they've benefited from this legislative remedy that's made them a citizen back to the date of their birth, and is that actually what's happened? And of course, we don't disclose any individual's information, but we had to confirm to the provinces in question that indeed the legislative remedies were retroactive, were giving citizenship back to the date of the birth, so that then the other jurisdiction could take that information and assess how it applied for the purposes of benefits to be extended to those applicants. Thank you.
So thank you. That's actually a pretty fulsome explanation. So provinces and I guess provincial agencies do sometimes request information from IRCC on a person's citizenship status and how it was acquired, or do they just ask, like, is this person a citizen, yes or no?
Ms. Girard?
It happens from time to time. The cases that I'm aware of, and operations is not my remit. I'm sort of more concerned with changes to the legislation and the regulations. But the provinces would come to us, especially after the legislative remedies passed in 2009 and in 2015, where persons were coming forward who were benefiting from the legislation, to understand whether the legislation was retroactive and to what point. And because it's not every day that Parliament passes legislation that has a retroactive effect, and that could have implications for the other jurisdiction in terms of other benefit applications that were being made. So it's because we're constrained by privacy legislation, I wouldn't be permitted to tell a person in a provincial authority whether the specific circumstances around someone's citizenship acquisition, but it was usually sufficient for them to have it confirmed that yes, the legislation was retroactive, and for the categories to what date, in this case, back to someone's birth. And that's what they needed to know in order to be able to move forward. Thank you.
So in this particular situation, it's the timeline that the sub-amendment touches upon that's the most important, but not the difference between right versus grant. That is not?
They're both important. They're both very important. In practical terms, though, the timeline does make an important difference for the reason that the member has mentioned. Thank you.
So I'm still looking at the sub-amendment. I'm just trying to grasp why you're saying the right versus grant is important, but in the description you gave, because of privacy legislation, you can't disclose to a province or provincial agency that's communicating with the department. They can just confirm the status. Yes, the person is a citizen, and as of what date they were a citizen. So I'm still uncertain how grant versus right is important in a situation like that, because that's in this sub-amendment. So I'm trying to grasp, like, why is that important? The dates I understand, I just don't understand this difference between the two. If you don't disclose it to the provincial agencies, then why is it important in the sub-amendment?
Thank you, Madam Chair. I'd like to come back to a different example, and that is, as discussed in the committee before, a person who is naturalized in Canada, who immigrates and who's granted Canadian citizenship, is able to pass on citizenship automatically to their child born abroad, who's considered the first generation born abroad. Whereas currently, someone who's a citizen as of right, generally that's someone who's born abroad, cannot. And so that is an important distinction. It's not got to do so much necessarily with provincial benefits administration, but it is one of the very important reasons why it's important that the law be clear and why this transitional provision consistent with similar provisions in past remedies is important. Thank you.
Ms. Trampel Gardner?
I'm good, thank you, Chair.
Okay. So seeing no further debate on the sub-amendment, we will go for a vote. We will be voting on the sub-amendment tabled by Ms. Lalonde. Mr. Clerk, if you can please take the vote.
Mr. Ali,
In favor?
Mr. Dhaliwal,
Support.
Mr. El Khoury, Madame Kayabaga,
Pour.
Madame Lalonde,
In favor.
Mr. Kimich,
Yes.
Mr. McGuire,
Yes.
Mr. Redekop,
Yes.
Ms. Rempel Garner,
Yes.
Mr. Brunet-Duceppe,
Oui.
Ms. Kwan.
Yes.
Yeas 11, nays 0.
The sub-amendment is adopted. So now we have NDP 5 as amended, and we will go to Ms. Lalonde.
Thank you very much, Madam Chair. As I explained at the beginning, I would also be bringing another sub-amendment to the NDP 5. So I would like to propose a second sub-amendment, and I move that NDP 5, proposing to amend Clause 1 of Bill S-245 by adding text after line 18 on page 1, be amended at paragraph 7.1 of subclause 4 by striking the text after the word subsection comes into force, comma, a person, and inserting the words who was born after April 16 of 2009, but before the coming into force of this subsection, and who is a citizen under paragraph 1B, is deemed to be a citizen under that paragraph from the time that they were born if A, at the time of the person's birth, only one of the person's parents was a citizen, and that parents was a citizen under paragraph 1B, C1, E, G, G1, H, O, P, Q, R, or both of the parents were citizen under any of those paragraphs, or B, at any time, only one of the parents, I'll repeat, B, at any time, only one of the person's parents was a citizen, and that parent was a citizen under any of the provision referred to its subparagraphs 3, B, I to VIII, or both of the person's parents were citizen under any of those provisions. And again, Madam Chair, these are very technical and very complicated sub-amendments. So this sub-amendment clarifies that a child born since 2009 who receives automatic citizenship due to the fact that their parents has a substantial connection is deemed to have been a citizen retroactively from the time of their birth, as opposed to only starting from when the bill comes into force. These sub-amendments also ensure that new G1 category, the former Section 8, is correctly included wherever it should be in the amendments for consistency purposes. Merci, Madame la Présidente.
We will have to suspend the meeting for a few minutes because the legislative clerk has a question, so there is some issue of the text. He has it and what you have read. So I'll suspend the meeting for a few minutes so that we can work on that. Thank you. Meeting is suspended.
Madam Chair, I want to commend the officials, for the great work that they have done and the intelligent answers that they bring forward to us. And I'm sure they will continue to till June the 15th that we are able to pass this bill. Madam Chair, as I see my watch is almost 5:45, so I bring the adjournment of the meeting, please.
No, let me just correct the record, please, for my amendment.
You can do that next time. No. Have more time.
No, please. Madam Chair, I just would like, just for the purpose of this exercise, for everybody to have a copy. I need to read it properly, if that's all right with my colleagues.
Thank you, Mr. Dhaliwal. If I think that would be good so that everyone has it. Let her read it because there was some confusion of the text which he read earlier. So I will ask Ms. Lalonde to read the text, and then we are coming to 2 hours at 5:56, so then we can adjourn the meeting. So Ms. Lalonde, if you can read the correct text for the sub-amendment.
Yes, and thank you very much, and I apologize for all my colleagues for this confusion. So I would like to move a second sub-amendment to the NDP 5, and I'll read it, that motion number 123-07559, proposing to amend Clause 1 of Bill S-245, be adding text after line 18 on page 1, be amended by substituting the following for the text of the proposed subclause 4, 2. 4. Section 3 of the Act is amended by adding the following after subsection 7, 2. 7.1. Despite any provision of this Act or any Act respecting naturalization or citizenship that was enforced in Canada at any time before the day on which this subsection comes into force, a person who was born after April 16 of 2009, but before the coming into force of this subsection, and who is a citizen under paragraph 1B, is deemed to be a citizen under that paragraph from the time that they were born if A. At the time of the person's birth, only one of the person's parents was a citizen, and that parent was a citizen under paragraph 1B, comma, C1, comma, E, comma, G, comma, G1, comma, H, comma, O, comma, P, comma, Q, or R, or both of the person's parents were citizens under any of those paragraphs, 2. Or B, at any time, comma, only one of the person's parents was a citizen, and that parent was a citizen under any of the provision referred to in subparagraphs 3B I to VII, comma, or both of the person's parents were citizens under any of those provisions. Merci.
So we have a sub-amendment. Just one second. Legislative clerk has just one quick question, so I'll pass it on to the legislative clerk.
Thank you.
Yeah,
Madam.
please go ahead.
Thank you, Madam Chair. Madame Lalonde, dans le libellé.
In the wording of the text, you're replacing the entire text of paragraph 4, 7.1, A, B, and C by what you're proposing, 7.1, A, and B. So C is being struck. Do you want to keep the C or no?
Ms. Lalonde?
Non, je ne.
No, well, now I'm mixed up with my languages. Hang on. No, C would be removed.
I hope everyone is clear on what sub-amendment she has tabled. Yes, Mr. Kimmich?
Sorry, Madam Chair. So is C in or is C out? I understood it was out. It's out? Okay.
Yes. Okay. So but I'll make sure that the clerk distributes to all the members in both official languages the exact text of the sub-amendment proposed by Ms. Lalonde. And with that, we have come to 2 hours of this meeting. So is it the will of the committee to adjourn the meeting? Okay, so the meeting is adjourned.
Yes.
Thank you. Huh?